Good morning, everyone. Happy Dashera. I hope you all are safe. Today, we have CS Yashri Dikshit with us. She is an Associate Company Secretary, a part with it, and currently pursuing her doctorate in analysis of corporate governance practices of selected Indian companies at GLS University, Ahmedabad. She is also certified independent director at IICA and currently practicing at Yashri Dikshit and Associates. She also have contributed in number of research articles in national and international journals. She is visiting faculty at renowned colleges like HL College of Commerce, Nirma University, Umia Girls College, and JG Commerce College. She also conducts several executive development and training programs for CS students. She is mock expert faculty member at Gujarat University and has taken various sessions on DTH channel at Educational Multimedia Research Center. Today, she is here to provide us with knowledge about intellectual property rights. Over to you, ma'am.
Thank you so much, Lisa. A warm welcome to all the students and welcome you all for session on intellectual property rights, a creative India and innovative India. I am C.A. Shiyastru Dikshit, practicing company secretary at Ahmedabad. The purpose of this session is to provide a general awareness on IPR, trademark, copyright, and various types of intellectual property rights. Now look into this picture. There are three members sitting in the chair, but all the three members are confused regarding whether he want to take patent, copyright, or trademark. I know in your mind there are so many questions arising related to if I have any innovative idea or if I have any innovative product. So should I register via trademark, copyright, or patent? So in this webinar, I will resolve all your doubt related to trademark and copyright. Now the first question arises in your mind, what is intellectual property? So in simple language, intellectual property is a new category of property. Intellectual property, that means you have idea what is intellectual. Intellectual that we didn't see, we didn't touch, it's called as an intellectual property. So the intellectual property is divided into two parts. Number first one, that is industrial property, and number second one, that is copyright. Industrial property is divided into four parts: patents, design, trademark, and geographical indication. In this session, I will clear your doubts related to trademark and copyright. Second, intellectual property is a handiwork of creative mind. Now, what is creative mind and what is creativity? Creativity, that means thinking of new idea for such as innovation and such as to create any new label, new symbol, new writing as a new book, any new name. But yes, this all are innovative. It's called as a creativity. Second question, what is the difference between invention and innovation? Do you have any idea about the difference between invention and innovation? So my dear friends, there is a difference between invention and innovation. When you are inventing any new product, yes, this product must be innovative or inventive. Now, what is invention? So, the invention is creation of a product or a process for the first time. And yes, it must be new or novel. What is innovation? So, the innovation is significant contribution in the existing product called as an innovation. Let's take example of invention and innovation. Example of invention is that any new product design or any new business model are covered under the invention. But in the same model, any addition in the same model are called as innovation. So there is a difference between invention and innovation. Intellectual property, it takes the form of an inventive solution or a means to harness an opportunity or overcome with the problem. So always think creative and inspire. Now the question arises, who can create intellectual property? So any teacher, any students, any banker, your friend, any company, either big or small size company, literally anyone can create an intellectual property. So there is no such age limit to create something innovative or the inventive. Yes, but all the idea must be inventive or innovative. If we are to succeed in realizing the country's innovative and creative potential through effective use of intellectual property, we need to change the people's attitude toward there is something innovation in the product and the incentive and the safeguards that IP right to provide. So in case in your mind any creative idea, so you can protect through the intellectual property rights. Next one, that is what happened. You do not protect your invention. So if you not protect your invention, there are chances that the somebody else might take patent, copyright, trademark, geographical indication, and design whatsoever any point. They will take all your rights from your product. Second one, competitors will take advantage of your invention. So easily your competitor will take advantage of your product or your new innovation. Possibility to license, sell, or transfer technology will be severely hindered. So there are chances that the somebody else might take license on that, somebody might sell your product. So this all are the chances if you not protect your invention. Your valuable time, your efforts, your labor work will be the loss and the funders will be discouraged. So these are the chances if you not protect your inventions. Look at this picture. In the first picture, how would you feel if someone copied your poem without your permission and got praised by the teacher? सही बात है ना? अगर आपने पोयम लिखा है और कोई आपकी पोयम को ऐसा शो कर रहा है कि ये पोयम तो मैंने राइट किया था, तो उस टाइम आपको कैसा लगेगा? Now, how you feel at that time? Now, imagine how an intellectual property owner feels when someone copies their novel, invention, or trademark without their permission and makes money from it. सो अगर आपने प्रोटेक्शन नहीं लिया है, इंटेलेक्चुअल प्रॉपर्टी राइट्स के अंदर आपने रजिस्ट्रेशन नहीं किया है, तो देयर आर चांसेस दैट द somebody else might take patent copyright on that, somebody will misuse your logo. So these are the chances. Better than you will be registered either in trademark or either copyright. Why intellectual property is required and why it is necessary to register. So number first, to protect your own unique creativity and invention, because it takes lot of time to create any new idea or make an inventive product. So you should protect your own creativity and invention registering with IPR. Number second, that is to get an economic return on funding invested in research and development. So you will get economic benefit from the government. Let's take one example. अगर आपने कोई ऐसा इनोवेशन किया है एंड रजिस्ट्रेशन किया है पैटेंट के अंदर, तो यहाँ पे गवर्नमेंट आपको 80% रिबेट का यहाँ पे आपको चांसेस मिलता है. चांसेस मतलब 80% आपको यहाँ पे फीस नहीं पे करना है. सो यू विल गेट इकोनॉमिक रिटर्न, यू विल गेट द इकोनॉमिक बेनिफिट फ्रॉम द गवर्नमेंट, बिकॉज इट विल टेक लॉट ऑफ टाइम to create your product or to create any new idea, to get your reward and recognition as it is a fruit of your hard labor, efforts and time, to own your invention and creative work, to create an intellectual assets for licensing and selling. So आपका जो ये आइडिया है, आप ये आइडिया को सोल भी कर सकते हो और आप उसको लाइसेंस भी दे सकते हो किसी और को यूज करने के लिए. एंड टू प्रिवेंट समवन फ्रॉम यूजिंग योर इन्वेंशन, इट इज इम्पोर्टेंट. जैसे हमने एग्जाम्पल देखा तो उसके अंदर क्या था, कि अगर आपकी पोयम किसी ने कॉपीराइट कर लिया है, वो ऐसा शो कर रहा है, तो ये तो पोयम मैंने राइट किया था। इन द सेम केस, अगर आपका कोई इम्पोर्टेंट, आपने कोई बुक राइट किया है या तो आपने कोई पोयम राइट किया है, आपका कोई इम्पोर्टेंट कोई नेम है, उसके ऊपर आपने ट्रेडमार्क लिया है, बट आपके ट्रेडमार्क रजिस्ट्रेशन से पहले वो कोई और यूज कर रहा है, तो आपके पास वहां पे कोई भी राइट्स अवेलेबल नहीं होंगे। नाउ इन द अदर केस, अगर आपके नाम के अंदर ट्रेडमार्क रजिस्टर है, आपकी जो पोयम है उसके अंदर आपने कॉपीराइट लेके रखा है, नाउ इन दैट केस you will file infringement case to the another person. So आप यहाँ पे infringement should file कर सकते हो. So these are the benefits if you register with the intellectual property right with the registry. What is intellectual property now? Earlier we have seen about what is intellectual property. Now, what is intellectual property rights? So intellectual property rights are legally awarded ownership right to the inventions. Why here I mentioned legally awarded? Legally awarded, that means register will issue the certificate of registration. It shows as legally awarded. And here the owner have various exclusive rights. What are the exclusive rights? That is right to sell, right to assign, right to license any one person. They give creator the right to prevent others from making unauthorized use of their property for a limited or the specified period of time. Limited period, that means each and every type of intellectual property right have a valid term period. Now, what is this term period? In case of the trademark, the validity of registration is at 10 years. But yes, after 10 years, you can renewal of trademark registration. In other cases like the patent, that is 20 years from the date of publication, copyright 60 years or the till the death of author. So these are the specified period of time you can use your rights, exclusive right. And yes, you can prevent someone unauthorized to use of their property. Now, what are the startup and IPR benefits? So, the startups have been recognized as a powerhouse of innovation, technology, and ideas. So, the government of India will start one scheme related to the SIPP, that is Startups Intellectual Property Protection for their innovation and creative, and promotes awareness and encourages IPR protection among the startup. So, अगर आपके माइंड में अगर कुछ ऐसा आइडिया है, कुछ इनोवेटिव प्रोडक्ट और इन्वेंशन कुछ टाइप का है, तो आप ये जो SSIP की स्कीम है उसके अंदर आप रजिस्टर कर सकते हो. You can get various benefits from that. Intellectual property rights are also an important reason behind the success of the Indian startup ecosystem. So here the government will provide various benefits to the startup. Investment made in technology that give a startup an advantage over incumbents, and others are always significant. So what are the advantage and benefit which will provide by the government of India under this scheme? Number first one point, that is the fast tracking of startup patent application. So the patent application is a fast track for examination and disposal. So आपको यहाँ पे first benefit कौन सा मिलेगा कि अगर आपने patent application file किया है, so within 6 months or within 1 year, it will be examined and the disposal. Number second, the panel of facilitators to assist in filing of IP application. Now you are students, so there are so many confusion in your mind. That is, हम लोग ये अगर हमारे दिमाग में ये कुछ इतना अच्छा सा आइडिया है, तो हम लोग उसको कैसे फाइल करें? अगर ट्रेडमार्क फाइल करना है तो कैसे फाइल कर सकते हैं? कॉपीराइट को कैसे फाइल कर सकते हैं? Now the government of India, which will provide the facilitators for providing general advisories in the different type of IPR, and also providing information protecting to IPR in India as well as outside of India. So this is the second advantage which will provide by the government of India. Third one point, that is the government to bear facilitation cost. Now the central government of India bear the entire facilitation of the cost for any number of patent, trademark or the copyright that design that startup may be filed, and the startups only and only bear the cost of the statutory fees. Entire facilitation cost will be borne by the government of India. So this is the third advantage. Next advantage, that is the rebate on filing of application. Now here in the case, if you are filing the trademark application, now the 50% rebate, that means 4,500 is the fees for filing the trademark registration. Now 50% rebate you will get while the trademark application will be filed with the registry, and the 80% rebate while the filing application with the patent. So this is the four benefits that you will be get by the government of India if your business will be registered under the Startup India. Number first, that we easily start a patent application, fast tracking process, entire facilitator cost will be borne by the government of India, and the rebate on filing application in case of the trademark and the patent. So this all are the benefits. Now, what are, or you can say, what are the various types of the intellectual property rights? So basically, there are six types of intellectual property. Number first, that is trademark. Second one, that is patent. Third one, copyright. Fourth one, industrial design, geographical indication, and the trade secret. Now, number first one point, that is trademark. For any brands, any logos, any slogan, any word bank, or any taglines you can file with the trademark. Patent, for any innovation in the product or the process you can file under the patent. What is copyright? Copyright for any literary and the artistic work you may apply for the copyright. Industrial design, for any aesthetic shape of particular product. Geographical indication, for specified place with the famous product you can apply under geographical indication. And last one, that is trade secret. That means any confidential business information, any process that you do not want to disclose with the general public, then you can take trade secret on that. So these are the basically six types of intellectual property. And in this session, I will discuss about the trademark and the copyright. Again, look this example, that is a Coca-Cola with a different IPR. So the Coca-Cola have taken different IPR only in the one product. You can see in this picture, Coca-Cola bottle. Coca-Cola have taken design for the particular shape of the product. They have taken patent on that because that is invention on making Coca-Cola product. So they have taken patent as well as trade secret on that. What is trade secret? Because they do not want to disclose the confidential information of the process of making Coca-Cola. That's why they had taken trade secret on that. Third one, that is trademark. Look, the name of Coca-Cola, right? So they have taken the name of Coca-Cola as a trademark, and yes, this is the registered trademark. Fourth one, that is copyright. Now, why they have taken copyright on that? Copyright for the advertisement of copyright. Advertisement of Coca-Cola, they have taken copyright on that. So totally they have taken 5 IPR only and only in their one product, Coca-Cola. Design, patent, trade secret, trademark, and the copyright. Next example, that is iPhone 7. Again, the different IPR in iPhone 7. Do you have any idea how many IPR they have taken? Again, they have taken 5 IPR only and only in their iPhone 7. Number first, that is the trademark. You can see in this picture iPhone 7, right? The name of iPhone 7, they have taken the trademark on that. Patent for the procedures of processor of iPhone 7. Design, you can see in this picture the particular layout or particular shape of iPhone 7. They have taken design on that. Copyright, again the advertisement of iPhone 7, they have taken copyright. And trade secret, because they do not want to disclose the process of making iPhone 7, that's why they had taken trade secret on that. Now look into this two example, iPhone 7 and the Coca-Cola. Both have taken different IPR only in their one product. So in case if you have any idea in your mind related to making any product or something like that, so you can take copyright, patent, trademark, or multiple IPRs only in their one product. Now let's start first type of intellectual property right, that is the trademark. In simple language, trademark is distinguish your goods and services with the other product. In simple language, trademark is distinguished goods and services with the other product. Can you guess this common trademarks, or do you have any idea about this type of trademark? Number first, that is Android, iPhone 7, McDonald, Pepsi, right? Superman. So this all type of trademarks are registered trademark, or it will be registered with the registry. So this all are the common trademarks. Now you can take trademark on particular name, particular logo, symbol, slogan, shape or color. First we will take name. If you have any idea about something unique name like the Coca-Cola, Coca-Cola have a unique name, so they have taken trademark on that particular name. Logo type. Do you have any idea about this symbol? It's a Nike symbol, so they have taken logo type in that trademark registration. Now the McDonald. So the McDonald have taken two types of trademark registration. The first one, that is the symbol, and the second one, that is the slogan. Symbol, that is M. M which shows the McDonald. That's why they had taken symbol on that. Next one, that is the slogan, that is I am loving it. So if you have any unique kind of slogan, so you can also register with the trademark. Let's take another example of slogan, that is the Subway. Do you have any idea about the Subway slogan? It's eat fresh. Do you have any idea about the iPhone slogan? That is think different. And yes, they have taken the registered slogan on that. Nike have a slogan like just do it. So this all type of slogan have a registered with the registry. Shape, the Coca-Cola shape particular, it will be also registered with the trademark, and the color, orange color, which also the registered with the trademark registry. Now, what is trademark? As I said the earlier, trademark, that means anything which allows the market to tell your product that is something innovative or different from all other products. And trademark cannot be too closely resembled with the someone else trademark covering the same or the similar product or services. A trademark must do more than simply describe your features and characteristics of your products and services. And yes, registration of the trademark is valid for the 10 years, and you can also renewal after 10 years for the further 10 years. Now, what are the functions of the trademark? It will be easily identified the source of goods and services. You can easily identify your goods and services. Because as I said, the McDonald have a registered trademark. So you can identify, yes, this is the McDonald product and this is the registered product. Uniformity must be mentioned in the quality of goods and services because it's a registered trademark. Goodwill will easily create in the market, easily differentiate your brand in the market because it's a registered one. It's advertise your product, it ensure the genuineness of the product. So these are the various functions of the trademark. Quality, uniform quality of goods and services, easily identified in the market, easily distinguished in the market. It will show the genuineness in the product. Now there is always confusion between when I can use TM and when I can use R. I know in your mind this kind of questions arise. What is trademark and what is a registered trademark? So in simple language, TM which shows the unregistered trademark. Once you make application with the trademark registry, after you can use TM of your particular product. Now look in this picture, Intel Inside, they have mentioned TM on that, right? TM, that means unregistered trademark. Your trademark, once registered with the registry, you can use R for that. R which shows registered trademark. This is symbol for R. And TM, it's only for TM, that is trademark, but it's unregistered trademark. Now the next one point, that is the SM. SM, that means service oriented establishment. For any unregistered service mark, they can use SM for your particular product. Now, what is the service oriented establishment, such as any banking sector, any communication sector, any telephone sector, real estate, any import export market, any finance? are using SM mark for that. So this is a trademark which may be designated by the following symbol. Always remember TM, that means unregistered trademark, not the registered trademark. And R, you can see in the McDonald, M, R, and I am loving it R. So the slogan is also the register mark and the logo is also the registered trademark. And TM, which shows unregistered trademark. Now, who may apply for trademark registration? So, any individual who want to register that particular name, that is, this name is distinguished with the other product and services, you can also register. So, any sole proprietor, any individual can apply for the trademark. Any partnership firm, any one of partner can apply for trademark registration. Any company, either private company, public, any listed or unlisted company may apply for the trademark registration. Any government organization can apply for trademark registration. Any education institute also can apply for the trademark registration, and trust company will also apply for the trademark registration. So this all are the 5 people can apply for the trademark registration. So proprietor, firm, company, government, and trust. Now this is the list of trademark classes. This is also important for you. Before application with the trademark registry, you have to check under which class your product has to fall. Now class 1 to class 34 it's a goods, and class 35 to class 45 it's for a services. So if you have any provide services relating to any computer software or software developer, so you can apply under class 42. Education institution can apply under class 41. Any medicines, then they apply for the class 5. You can also make application with the multiple classes, right? So these are the list of trademark classes. So first of all, you have to check under which class your trademark goods or either services will be for. After that, you should check trademark registry whether this particular name is available or not. Because the same name is already registered with the registry, then you cannot apply your name, right? Next one, what type of trademark can be registered? So any word or the combination of words, as I say, that is the Google, right? So Google have already registered trademark. Any letters, that is McDonald, only the particular M letter is a registered. Any numericals numbers can perfectly constitute a trademark. A trademark may also consist of the device, any brand, any heading, any label, any ticket, name, signature, word, shape of goods, packaging, or the combination of colors can apply under the trademark registration. So if you have any particular or the unique name, in fact unique signature, any word, shape of goods can apply for the trademark registration. Now, what cannot be registered as a trademark? So, if your words is not distinguished with the other goods and services, you cannot apply it under the trademark. Such as example like the Indian flag, you cannot register this particular flag with the registry. Any god name, like you cannot apply the name like the Saraswati, Parvati, this kind of name you cannot apply. Any common words which is common in use, which cannot be applied for the trademark registry. A square can be trademarked for any product or services, but it cannot be trademarked for a product which is a square in a shape. So if your trademark, the product is a square in a shape and the name of the product is also square, now you cannot register under the trademark. And trademarks that offends the community or the religious sentiments cannot be a trademark. So which is against the public policy or the against the morality, against the religious sentiments, you cannot apply it as a trademark. Let's take example for that. You cannot apply Om name for your particular product or the symbol of Om name or any other which is against the morality or the public policy. You cannot register as a trademark. So these are the various types of trademark, like the word mark, second one that is the collective mark, certification mark, a sound mark, logo mark, 3D mark, that is 3 dimension mark, and the smell mark. So these are the total 7 to 8 types of the various types of the trademark. Let's take number first type of trademark, that is the word mark. Word which shows any particular name of particular product, you can register as a word mark. Second one, that is the collective mark. Collective mark, that means a mark adopted by the collective, that is association, union of the cooperative or the other organized collective person can use by these members as a collective mark. For an example, any LIC agent can use LIC logo because they are the agent of the Life Insurance Corporation of India, so they can use the LIC symbol. It's called as a collective mark. Number third, that is a certification of mark, which shows the certified of any goods and services, ISO 19000, ISO 2001. So this are they can use a certification mark. Service mark, already I discussed with you, service oriented establishments such as any telecommunication services, any real estate import export activity can be registered as a service mark. Sound mark, this is again the this is again the unique type of mark, or you can say is the unique sound mark. What is the sound mark? Sound mark which protect a sound in relation to the goods or the services. And the Intel, or you can say the Yahoo Yodel registration was the first sound mark registration in India in the year 2008. So this is again the new type of trademark registration under the sound mark. Logo for the particular symbol of particular product. 3D, that is a 3D dimension marks you can register with the trademark registry, which shows a combination of a product, colors or services. And the smell mark, in case of any unique smell in your particular product, so you can also register with the registry as a smell mark. So these are the various types of trademark. Either you can register under the word mark, certification mark, collective mark, sound mark, logo mark, 3D mark, or the smell mark. Now, what are the advantages of trademark registration? So, these are the advantages. Number four, that is create the brand awareness. You can easily create the brand awareness in the market, which develop in your company as an important intellectual property or as a business asset in your company, which will create a build or brand image in the market. You can protect for 10 years and also renewal right with the owner. So after the completion of 10 years, you can also renewal of the trademark registration. You can also register in India or as a outside of India. So both the right will be the exclusive with the owner, which attract the human resource and protect the goodwill and the brand in the market. Now it's game time. Now find out the famous trademark in that. So do you have any idea about in this box what are the famous type of the trademarks or which is already known to you? Do you can you guess this common trademark? First one, that is the, you can see this is the Pepsi. This is again the famous trademark Pepsi. Second one, that is the Cadbury. Again the Cadbury having the registered trademark. So this is the Cadbury. Third one, that is the Amul. You can see the Amul is also the registered trademark. Next one, that is the Tata. Again the Tata have a registered trademark, right? Next one, that is the Lux. You can see in this picture the Lux is also the registered trademark. Next one, that is the Bata, right? So Bata company is also registered trademark. So these are the famous trademark registered in India. Now question arises, how do I register a trademark? So number first, you can file the trademark registry at the Indian Trademark Registry. www.ipindia.nic.in is the website of the trademark registry, which contain all the information that you need. You must be file the application, which in this application must be mention your name, address. If you have appoint any trademark agent, then must be mention the name of trademark agent, particular of your logo mark or the word mark or the symbol mark, or the goods and services which you use or will use in the future. So you must be name of the particular, or you can mention the date of particular that you have the starting this product from this and this years. The trademark registrar will examine the application. So, and after the clearing the application stage, your trademark will be published in the trademark journal. So the trademark registry consider your application. In case of any objection will be raised by the trademark registry. So within 2 months they will issue the objections and you have to file within 30 days. and there is no such kind of objection, then it will be published in the trademark journal. And if no one challenge your trademark application, then your trademark will be registered for the 10 years, and you will be renewal after the 10 years. So it will be very easy process, and you can easily register with the trademark registry. Now, what is a copyright? Till now, we have discussed about the trademark and what is the intellectual property and what is the intellectual property rights, startups and IPR benefits. Now, we will discuss what is the copyright. So, Copyright Act, which came in the year 1957, and till now there is so many amendments occurred till the 2012. What is the object of copyright law? The object of copyright law is to encourage authors, composers, and the artists to create original works by the granting them exclusive right to make the copies and sell number of years, right? So each and every intellectual property right have an exclusive right given to the owner. As I said, what is the exclusive right? Exclusive right, that means rights which is given to the owner. They can sell, they can assign, they can license to any person, but yes, the other person make permissions to the owner of that particular product, or you can say the author, composers, or the artist. Now, what is copyright? So copyright is an exclusive right which is given by the law to the creator of the literary, either dramatic, either musical and artistic work, and the producer of cinematograph films and sound recording for a limited period of time. Again, limited, that means specified period, you can get the protection of your work. Copyright protection must be remembered that the work must be original, not copy from the other person. As I said, or as I have given example like the poem, if someone is copied your poem and उन्होंने क्या बताया था कि ये पोयम तो मैंने राइट किया है, बट वो तो आपका ही था, राइट? तो आप उसके ऊपर प्रोटेक्शन नहीं ले सकते हो, क्योंकि द वर्क मस्ट बी ओरिजिनल और ऑथर जो है वो आप ही होने चाहिए. So the work must be original, the work must be fixed or presented in a tangible form such as writing, film or photography. So you can see the work like such as a writing or films, Hollywood film or the Bollywood film, they have most taken copyright on that. Photography, you can take photography on that copyright, and yes, must be created by any qualified person. This chart is important for you because copyright protects so many works like the artistic work, literary work, musical work, or the dramatic work, and many more. Artistic work, that means if you have any graphics or if you prepare any cartoons work, so you can also take copyright on that. Photography, you can also protect on that. Any drawings, any maps or any diagrams, model of particular building. So if you have a like the architecture work, so they have prepared first of all the model of building, so also they can protect the copyright on that. If you have a writing any books or a writing any poem or writing any research paper or a article, so you can take copyright on that, because if you not copyright on that, somebody else might taken your work without taking prior permission to you. So this is important कि आपको उसके ऊपर पहले से ही कॉपीराइट ले लेना चाहिए. Any song lyrics, instruction manual, computer software. In case of the website, you can take the copyright of your particular website of company and the ebooks. Musical, if you have any advertising, any jingles or the pop song or the melody songs, you can take copyright on that. Any choreography, that is again something unique or new, you can take copyright on that. So these are the four types: artistic work, any literature work, any musical works or dramatic work, you can take copyright on that. Next one, that is the films or sound recording and the broadcast. Any television advertisement or interactive games or interactive films, you can take copyright on that. Sound recording, any digital music, any DVD or the CD player, you can also take copyright on that. And the broadcast, that is free to air or pay radio and TV, so you can take copyright on that. So these are the various types of works that you can take copyright on that: artistic, literary, musical, dramatic, films, sound recording, and the broadcast. Now the copyright, which in essence of the bundles of rights. Bundles of right, that means number first, that is reproduction. आप वही जो पर्टिकुलर प्रोडक्ट है, पर्टिकुलर आपका जो वर्क है, उसको आप रिप्रोड्यूस कर सकते हो. नंबर सेकंड दैट इज द मॉडिफिकेशन, आपको वही वर्क के अंदर कोई चेंज करके फिर से वो मार्केट में पब्लिश करना है, देन यू कैन डू इट. सो मॉडिफिकेशन विल राइट ओनली एंड ओनली विद द ओनर. Distribution, you can sell number of copies to the and a number of persons. So distribution right will also available only with the owner. Public performance and the public display, so these are the particular 5 rights, and yes, it is only and only available with the owner. Reproduction, modification, distribution, public performance and the public display. Now, who is the author? So different work have a different author. Number first, that is literature work or the dramatic work, right? So the person who is the author of the work, the person who is writing the novel, the person who is writing this article, it's called as the author of the work. Number second, that is the musical work. Musical work, that means the composer who composed this particular music. They can take copyright on that. Cinematographical films and the sound recording, the producer, the person who produced the films, will take the copyright on that. Photography, the person who taking the photograph can take copyright on that. Artistic work other than photograph, the artist. Any literary, dramatic, musical or the artistic work which is computer generated, the person who actually the owner or who actually the cause the work to be created is called as the author. So this is the author of the work: literary, musical, cinematographical and the photographical work. Now the term of copyright, as I said, the intellectual property rights will be the specified time period. In the trademark, we have seen the trademark validity is 10 years, but you can also renewal after the 10 years. In the same like the case of the copyright relating to the literary, musical or the artistic work, lifetime of the author you will get the protection plus 60 years after the years of the death. So जब से author का death हो जाए till the 60 years उनकी validity है, or the lifetime of the author. So this will be protected till the lifetime of the author. Work which is published unanimously, then the 60 years after the year in which the work is first published. So 60 years will be the validity. You cannot renewal after that. Identity of author disclosed before the expiry of the said period, and the 60 years following the year which the author dies. In case of any photographs, cinematographical films or the sound recording, then that will be the term period of the 60 years after the years of that particular period. So this is the term of copyright and the specified time period which is prescribed under the law, and you can use the work after the particular period. Now, what is the infringement of copyright? If someone is using your work without the prior permission, then the infringement of right which will be issued by the owner. So the copyright is infringed when a person without the license from the owner does something exclusive right of which is given to the owner. जैसे कोई भी आपका कोई वर्क है, फॉर एन एग्जांपल इफ यू पब्लिश एन रिसर्च आर्टिकल और किसी ने वो आर्टिकल के ऊपर आपने कोई कॉपीराइट नहीं लिया है, बट इफ द सेम person or the other person is using your work without prior permission, बट अगर आपने वो आर्टिकल के ऊपर कॉपीराइट लिया था, नाउ यू कैन फाइल इन्फ्रिंजमेंट केस टू द अदर पर्सन, क्योंकि किसी ने आपका जो वर्क है आपकी प्रायर परमिशन के बिना वो लिया है. नाउ यू कैन फाइल द इन्फ्रिंजमेंट सूट ऑफ दैट पर्टिकुलर पर्सन. In case of the literary or the dramatic or the musical, the artistic work, a reproduction thereof. तो कोई भी जैसे कि आपका रिसर्च पेपर था, आपकी कोई बुक थी, तो रिप्रोड्यूस फिर से ही वो बुक के थोड़े बहुत वर्ड्स है उनको चेंज करके फिर से उसको रिप्रोड्यूस कर दिया. नाउ यू कैन फाइल द इन्फ्रिंजमेंट suit to any person. Cinematographical films, a copy of the film, a copy of the any Bollywood film or the Hollywood film, they can file the infringement suit against any person. Any sound recording, any other sound recording, employing the same sound recording, same उन्होंने sound recording कर दिया और ऑलरेडी उन लोगों ने कॉपीराइट लेके रखा था, फिर भी उन्होंने ये चीज किया. नाउ दे विल फाइल इन्फ्रिंजमेंट केस टू द अदर पर्सन. Program or performance in which the broadcasting, reproduction or the performance rights subset the sound recording or the cinematographical films of such performance. Now the any person who will reproduce your work, who will copy your work without prior permission of the actual owner, then they will file infringement case. They will file infringement case to the other person who will using their work without prior permission. Now, how do I protect my copyright work? So your copyright will be arise in a work as soon as you create it. So जैसे आपने आपका जो work है वो prepare कर दिया है, either your book, writing research paper, article, anything else. So there is no legal need to the register it. However, having the copyright registration is a strong proof that you are the actual owner. So it is a compulsory that you are the actual owner. And the second one, that is you don't copy your work from other places, और आपने जो आपका वर्क है कहीं से भी वो कॉपी नहीं किया है उसका आपको ध्यान रखना है. Number third, you can file an application to the register your copyright at the http copyright.gov.in. So ये specified the website है. Now you can file application on that. If no third person objects to your application and your application passes the examination stage, the copyright office will grant the copyright registration for your work. So within 6 months, you can get the right, that is R symbol, or you can see the C symbol for your particular work. So no one have an objection related to your work or related to application. So the copyright registry will issue the copyright registration of your work. So this is the all about the trademark and the copyright. Basically you have to think over that कि आपका जो भी work है, either in case of the copyright or either in case of the trademark, that must be innovative or something unique. This word does not available to the public. ये आपको ये दो चीज का बहुत ही ध्यान रखना है. Because whenever you make a file application either with the trademark registry or the copyright registry, they will directly check कि आपका ये application है और आपका either in trademark the word, either the device application or either the sound mark already known to the public or already available in the public. सो आपकी जो एप्लीकेशन है विद इन 30 days के अंदर ही वो क्या हो जाएगी, रिजेक्ट हो जाएगी. सो यू हैव टू टेकन केयर ऑफ ऑल दिस थिंग्स while you are making application with the trademark registry or the copyright registry. Right now you have any questions, so you may ask.
Uh, Thank you so much, ma'am, for providing this amazing knowledge on intellectual property. I also did not know some of the trademark like sound mark, spell mark, and third dimension mark. So it was really amazing. And here are some questions asked by the students. Like, are they having some unregistered trademark rights? Do they have?
Sorry, can you please repeat the question?
Do unregistered trademark have any right?
An unregistered trademark does not get any right once your application with the register and you get the symbol of the registered trademark. After you can file infringement suit to the against any person.
Okay, ma'am. And how much time does it take to register a trademark?
It will depend upon your application. It's like procedure like that. First of all, you make the application with the trademark registry. Within 10 days or within 15 days, you will get the reply from the trademark registry. Either your application is accepted or rejected. So if they have any query related to your trademark, for an example, one of my client make the application related to the Khatar wale, right? So the Khatar wale name will not be available with the registry. So within 13 days they have accepted and advertised in the trademark journal. So आप जो भी नाम है वो select कर रहे हो वो must be available होना चाहिए और किसी का भी ये नाम नहीं होना चाहिए. So once it is accepted, then it will be advertised in journal. So it will take approximately 6 months or maybe it 1 year. So it depend upon case to case.
Okay, ma'am. And how did the need for the copyright arise?
How would be the?
How and when did the need for copyright arise?
Okay, copyright arise. As I take various example like the writing any book or writing any research article or research paper. So आपको ऐसा लगता है कि ये जो पोयम है या तो रिसर्च आर्टिकल है वो सिर्फ आपने ही बनाया है ना, ये जो वर्क है आपका कोई भी कॉपी ना करे और वो कॉपी करके वो मार्केट में डिस्ट्रीब्यूट ना करे. Now you will take the copyright on that. So on the same day you will make the application with the copyright registry, and within 6 months or within 2 to 3 months they will get the copyright in there on your work, if your copyright work is not resemble or not related with the any other work.
Okay, ma'am. Thank you, ma'am. That's all our questions. And thank you for connecting with us and sharing this immense knowledge on copyright. Uh, Thank you, ma'am, and thank you, audience, for staying connected with us for this wonderful webinar. And stay tuned for the next mathematics workshop.
Yeah. Thank you so much, all of you.
Thank you, ma'am.